Real-world supervision, where law meets daily practice. As we continue through this course, this section brings everything together through real-life legal scenarios that brokers face every day. Up to this point, we have discussed supervision, delegation, discipline, and systems. Now we apply those concepts to real situations where decisions must be made quickly and correctly. These are the moments where brokers either protect their license or put it at risk. Change of brokerage. Name and resignation of designated broker. A brokerage operating as an Arizona corporation decides to change its name as part of joining a national franchise. At the same time, the designated broker resigns. The question becomes, do current clients need to consent to these changes? The answer is no. As long as the same legal entity, the corporation, continues to represent the clients, their consent is not required. However, the brokerage must properly amend its articles of incorporation with the Arizona Corporation Commission and follow publication requirements. Real-life takeaway: clients hire the brokerage entity, not just the individual broker, but operational changes must still follow legal corporate procedures. Departing agent and existing clients. Who owns the relationship? An agent leaves brokerage A and joins brokerage B, but wants to continue working with buyers currently under contract. The answer is clear. The agent cannot continue representing those clients unless the original broker employment agreement is terminated and a new agreement is signed with the new brokerage. Real-life takeaway: the relationship belongs to the brokerage, not the agent. Moving brokerages without proper documentation creates immediate legal risk. Temporary absence of the designated broker. What happens if a designated broker leaves for a short period, vacation, illness, or travel? Under ARS paragraph 32-2127, the broker may designate another qualified individual to act on their behalf for up to 30 days. This must be done in writing, retained for 1 year, and attached to relevant filings. Real-life takeaway: supervision never pauses. If the broker is gone, someone must legally step in, with documentation. Reporting misconduct: optional but powerful protection. A broker discovers misconduct by an agent under their supervision. Are they required to report it? No, but under AAC R4 28-1103F, if the broker does report the violation immediately, they may be protected from disciplinary action for failure to supervise. Real-life takeaway: reporting is not required, but it can protect the broker. Silence can increase liability. Document review timeline: a common compliance mistake. A broker mistakenly believes documents must be reviewed within 10 days after closing, instead of within 10 days of execution. Under ARS, paragraph 32-2151-01G, documents must be reviewed within 10 days of execution, not closing. While the broker may not lose their license for this mistake, penalties can still apply. Real-life takeaway: timing matters. Administrative errors are still violations, even when unintentional. Disclosure of licensee status: what counts as proper disclosure? A landlord who is also a licensee provides a business card disclosing their status before a lease is signed but does not include it in the contract. This satisfies AAC R4 28-1101E, which requires disclosure in writing at or before the transaction. Real-life takeaway: disclosure does not have to be complicated, but it must be clear, timely, and in writing. Working for multiple brokerages: a hard-line rule. A licensee attempts to work as a transaction coordinator for 2 brokerages at the same time. Under AAC R4 28306A2, this is not allowed. A licensee may only perform services for their employing broker. Real-life takeaway: there is no dual employment in Arizona real estate. 1 licensee, 1 broker. How this section connects forward. This section reinforces a powerful concept. Most violations are not intentional. They are the result of misunderstanding, poor systems, or lack of supervision. As we continue, we will see how these real-world mistakes translate into liability, lawsuits, and insurance claims. The pattern continues: knowledge, plus systems, fact, protection. Online discussion. Question 1. Why can't an agent take their clients with them when switching brokerages? Answer: because the broker employment agreement is between the client and the brokerage, not the individual agent. A new agreement must be signed with the new brokerage. Question 2. What is the benefit of reporting an agent's misconduct to ADRA? Answer: while not required, reporting may protect the broker from disciplinary action for failure to supervise under AAC R4 28-1103F. Question 3. What is one of the most common administrative mistakes brokers make? Answer: failing to review and initial documents within 10 days of execution as required by ARS. Paragraph 32, 2151.01 G.